Greetings everyone. Welcome to this lecture of Indian polity. Dear aspirants, in today's session we are going to discuss about a very significant topic, and there is high possibility that this question from this topic may be asked in upcoming prelims 2026. And today's topic is right to vote. So in this video lecture we will find out that whether right to vote in India is constitutional or statutory, right? And UPSC has already asked a question in 2017 prelims 2017 from this topic. So let's see the question. So in 2017, UPSC flips, right? So the question was right to vote to be and to be elected in India is a first option fundamental right? No. Second option natural rights? No. Third option constitutional right? Yes. So that time UPSC considered right to vote and to be elected in India as constitutional right. But almost 8 years, more than 80 years have been passed, and several judgments of Supreme Court have been come. So the situation has changed, right? And in this video lecture we will clarify that whether right to vote in India is statutory or constitutional, right? Now, so here first we will discuss what is right to vote. So in simple terms, you have to understand that right to vote is also called suffrage, right? Means instead of right to vote you can also use the term suffrage. And if you read article 326, you will find that article 326 uses the term adult suffrage, not right to vote. So now what is right to vote? So in simple terms you can define that right to vote is the legal right provided to individuals to participate in the electoral process so that they can cast their vote and participate in the elections. Simple. Now here first we will discuss the constitutional provisions, then we will discuss the statutory provisions, means the Representation of People Act 1950 section 16 and section 19, then Representation of People Act section 62, right? So first we will start from constitutional provision. So article 326 of Indian Constitution, it simply says that elections to the House of People, Lok Sabha, and to the legislative assemblies of a state to be on the basis of adult suffrage. As I said earlier, that right to vote, right, is also called as suffrage, and article 326 uses the term adult suffrage. Adult suffrage, see, in India, in simple terms, you have to understand that anyone who is not less than 18 years, right, is considered as adult, right? In different acts it vary, right? In some cases, for example, in certain criminal cases the age is 16, right? In certain matters like property related issues it is 21 years, but in most of the cases, even Indian Majority Act, it considers, right, 18 years as adult, right? So in simple terms you have to understand that in India anyone, right, who is 18 years or above has right to vote, right? And where it is written, it is under article 326, means elections to the Lok Sabha and election to the state legislative assemblies are to be based on adult suffrage. That is, adult suffrage means what? Anyone who is 18 years or above, right, irrespective of caste, class, gender, whatever. Clear? Now, so you can clearly see that the word right to vote has not been used in article 326, but let's make it more clear. Read section 16 of Representation of People Act 1950, right? So it says, section 16, Representation of People Act 1950, it says there are two subsections, right? Subsection 1, subsection 2, and subsection 1 has certain clauses. So first, section 16 says disqualification. It talks about disqualification for registration in an electoral roll. Electoral roll is simply called as voters list. We call it voters list, right? So a person, subsection 1, it says a person shall be disqualified from registration in an electoral roll if he is not a citizen of India. Means if you want to get your name registered in the electoral roll, you must be citizen of India. If you are not a citizen of India, your name shall not be registered in the electoral roll or called as voter list. First. Second condition, is of unsound mind and stands so declared by a competent court. If you are a person of unsound mind means if you are insane, mad, right? You have lost your consciousness, and it must be declared by a competent court, not by a person or individual, right? Then again, you are not allowed to register your name, get your name registered in electoral roll, right? Third condition, for the time being disqualified from voting. Disqualified from voting under which provision? Under provisions of any law relating to corrupt practices or and other offences in connection with elections, right? Corrupt practices, for example, like corruption. If a person has been convicted under Prevention of Corruption Act 1988, right, or any other election related violations, right, that person is also disqualified from registration of electoral roll. Clear? So three conditions. First, if the person is not the citizen of India. Second, the person is of unsound mind. Third, the person has been disqualified from voting under any law, right? So such person's name should not be or would not be enrolled in the electoral roll. Clear? And when your name is not in the electoral roll, you are not allowed to vote. Even you are a citizen of India or you have attained 18 years or above, you are not allowed to vote. Clear? Now, subsection 2 of section 16. So again, this is very important. It says the name of any person who becomes disqualified after registration shall forthwith means immediately, without any delay, right? So be struck off the electoral roll in which it is included. So in simple terms means if the person has been disqualified after registration, just an example, person X, his name was registered in the electoral roll, right? But due to some reason, we have seen the reasons, right? He is disqualified, right, after registration. Then his or her name must be struck off from the electoral roll immediately. Forthwith means immediately, without any delay. His or her name shall not remain in the electoral roll, only known as voter list, right? But here is a condition: the name can be reinstated. Reinstated means the person's name can be re-registered in the electoral roll. How? If provided that the name of any person is struck off the electoral roll of a constituency by a reason of clause C of subsection 1, we have seen, right, due to malpractices, right, or corruption related issues, right? So shall forthwith, again forthwith means immediately, without any delay, be reinstated in that roll. That roll means electoral roll, right? If such disqualification is during the period of such roll is in force and removed under any law authorizing such removal. So in simple terms, right, the person's name has been removed from the electoral roll, but due to some reason, right, the court has what rejected the conviction of the person, right? So with immediate effect, without any delay, the person's name should be reinstated, means re-registered in the electoral roll. That is the simple explanation. Clear? Now, section 19. This is very important, right? So section 19, it provides conditions for registration. So see, section 16 provides conditions for disqualification, right? But section 19 provides conditions for registration, and there are two conditions. First, the person should not be less than 18 years of age. So in India, anyone who is not less than 18 years, right? So if you have attained your 18 years, right, your name should be enrolled or registered in the electoral roll. First condition. Second condition, ordinarily resident. See, section 20 of Representation of People Act, right, it defines ordinarily resident, but it is very complicated, right? No need to read the words line by or lines word by word. So here in simple terms, I am telling you that ordinarily resident simply means that you should be a permanent resident of your constituency, right? Not a temporary or casual resident. right? For example, so many students are studying in Delhi or in different cities of India. It does not mean that their name will be registered in the electoral roll of that city, right? Your name would be registered only electoral roll of your own constituency, right? Even for example, UPSC aspirants are residing in old Rajendra Nagar or different locations of Delhi, right? For years, 5 years, 6 years, 3 years, whatever. It does not mean their name would be registered in the electoral roll of Delhi, right? Simple. So you should be the permanent resident. Ordinarily resident in simple terms means permanent resident in your constituency, not on casual or temporary basis. Clear? Now, section 62 of Representation of People Act 1951. Very important, right? Now, subsection 1, it says, section 62, it talks about right to vote. So, there are 6 subsections. So, first subsection, see, I am telling you that the words are very lengthy, right? Sentences are very lengthy in actual law, right? So, I have tried to make it very simple, right? So, just try to understand. So, subsection 1 of section 62, it says, every person whose name is entered in the electoral roll of a constituency has right to vote. So, you can clearly see section 62, subsection 1, it talks about right to vote. If your name is registered in the electoral roll, means voters list, right, you have right to vote, right? So, in that sense, it should be statutory right. Clear? Now, subsection 2, it says, no person can vote in any constituency if he is disqualified under section 16 of Representation of People Act 1950. So, under section 16, Representation of People Act, we have seen 3 conditions for disqualification from, right? For disqualification to be registered in the electoral roll. First condition, the person is non-citizen. Second condition, the person is of unsound mind. Third condition, person has been disqualified from voting. For example, corrupt practices or any other illegal practices, right? So, now subsection 3, it says, no person shall vote in more than one constituency, right? So, one person can vote from only from one constituency, not from other constituency or more than one constituency. Where it is written? Subclause 3. Sorry, subclause not, subsection 3, right? Subsection 3 of section 62. Again, subsection 4. Again, very important. No person can vote more than once in the same constituency. So, 3 prohibits the person from voting more than one constituency. Subsection 4 prohibits a person from voting more than once in the same constituency, right? And if he or she does so, if, for example, person X, right, casts a vote more than once from his or her own constituency, then it shall be void, right? Invalid. All your votes shall be invalid. Okay? So just remember, subsection 3 prohibits a person from voting more than one constituency. Subsection 4 prohibits a person from voting more than once in the same constituency. So just remember, one person, one vote, one constituency. Clear? Now, subsection 5 and subsection 6. So again, subsection 5 is very important. Why important? Generally, aspirants think that, and even, right, as a common citizen of India, you might be thinking that whether a person who is in prison or a person who is in custody has the right to vote or not. The answer is no. Means it is clearly written in subsection 5 of section 62 Representation of People Act 1951. It simply says that prisoners and persons in custody, right, no person can vote at any election, right? If the person is confined in prison, if you are a prisoner, you are not allowed to vote. Though your name will remain in the voter list, electoral roll, but you are not allowed to vote. Clear? Right? Whatever could be the condition, centers of imprisonment, transportation, or otherwise. Second condition, in lawful custody of police, even you are not in the prison, right, but you are under any lawful custody of police, that time you are also not allowed to vote. Clear? But there is an exception. What is the exception? If the person is under preventive detention. Preventive detention means, so if means preventive detention in simple terms, when a person is detained, right, to prohibit that person from committing crime. The person has not committed any crime, but he is detained so that he could be, or he or she could avoid any crime, right? That is called preventive detention. So preventive detention is exception. That person means here, if a person is under preventive detention, he or she is allowed to vote. Clear? But who is confined in prison or under lawful custody of police, both these persons are not allowed to vote. Simple. Next, subsection 6. This is very important. It is related to proxy voters. What is proxy voter? So simply, just imagine that person X, right, is an army personnel, right? Army personnel, right? But he is not allowed to, means he is not available to cast his or her vote. Simple. So what is allowed means, under subsection 6 of section 62 of Representation of People Act, proxy voters are allowed. Proxy voters are allowed means that person can choose one person, for example, his or her own family member, right? His brother, just an example, person Y is her brother or his brother. So he can give his voting right to this person as, and Y will vote on behalf of person X. This is called proxy voter. Person Y is proxy voter. He is voting on behalf of his or her brother. Right? That is the simple meaning of proxy voter. And other examples are there: army personnel or person who are deputed in state government service or central government services. Right? And currently not in their own constituency. Right? They can also choose a proxy voter. Clear? So here, subsection 3 and 4. Subsection 3 and 4 prohibits, right, more than one voting. Clear? So section 3, subsection 6, right, is exception to subsection 3 and 4 of section 62, and it is related to proxy voters. So here, as Y, right, Y would have casted his vote, right or not, right? Again, he is casting on behalf of X, so he is voting twice. One, his own vote, and second, the as a proxy voter. That's why subsection 3 and 4 is except, means section 62 subsection 6 is exception to subsection 3 and 4. Simple. It is related to proxy voters. Now certain cases, right, it will help you to understand whether right to vote is constitutional right or statutory right. So simply, right, in NP Ponnuswamy versus returning officer 1952, in this case, right, Supreme Court upheld that right to vote is statutory right, right? Representation of People Act section 62, right? We have seen. Clear? So in this case, NP Ponnuswamy case, Supreme Court clearly mentioned that right to vote is statutory right. Again, Jamuna Prasad Mukhariya and others versus Lachiram and others 1954. Again, same was repeated by the Supreme Court, that right to vote is statutory right. Clear? Again, Jyoti Basu versus Devi Ghoshal 1982. Again, same thing was upheld by Supreme Court, that right to vote is statutory right. So in all these three cases, NP Ponnuswamy case, Jamuna Prasad Mukhariya case, or Jyoti Basu case, right, Supreme Court upheld that right to vote is statutory right. Clear? Now, another important case that came in 2003, right, that is called PUCL versus Union of India, right, 2003. And in this case, Supreme Court took a turning point. Took a turning point means it was a bench of 3 judges, right? And there were 3 judges: Justice Reddy, right? Justice Shah, right? And Justice Dharmadhikari. And all these 3 judges had different opinions regarding right to vote, right? So first, Justice Reddy, he opined that right to vote is not purely statutory right, and he mentioned that it means right to vote has origin in Article 326, as Article 326 mentions that adult suffrage. So Justice Reddy opined that right to vote in India is not purely statutory right, and it has origin in Article 326, right? Then came Justice Shah. He upheld earlier judgments of Supreme Court, and he simply said that no, right to vote is statutory right. Clear? Now, Justice Dharmadhikari, right? He tried to balance the judgment. Balance the judgment means he said that right to vote is statutory right as well as constitutional right, right? And why? Because he said that right to vote is ambiguous. Article 326 indirectly mentions right to vote, and certain sections of Representation of People Act also mentions right to vote, right? That's why he opined that, Justice Dharmadhikari opined that right to vote is ambiguous, and hence he upheld that it is both statutory right as well as constitutional right. Clear? Now, another important case, Kuldeep Nair case. So Kuldeep Nair case 2006. So here again Supreme Court upheld that right to vote is statutory right without any if and but. Clear? Now, again important case, PUCL, actually PUCL, People's Union for Civil Liberties, right? So again PUCL versus Union of India 2013. This is again a landmark judgment in the election history of India. Why? Because in this case, for the first time, Supreme Court distinguished between two, means right to vote, right? It distinguished between right to vote and freedom of voting. Clear? And again, you must be knowing nota, right? Nota option, right? It was introduced by this judgment. So in PUCL versus Union of India 2013, it was upheld that, means there is difference between right to vote and freedom of voting. Clear? And freedom of voting is related to Article 19 clause 1 subclause A, freedom of speech and expression. Clear? Now, another judgments, Rajwala and others versus Union of and State of Haryana and others 2015. So in this case, Supreme Court clearly mentioned that right to vote is what? Constitutional right. Is constitutional right. Simple. Why constitutional right? Because it took preference from PUCL versus PUCL case 2003, right? And in 2000 PUCL versus Union of India case 2003, right? 3 judges had different 3 opinions, right? And most of the judges had inclination towards constitutional right. So in Rajbala and others versus State of Haryana and others 2015, it was upheld by Supreme Court that right to vote is constitutional right. And as UPSC asked the question in 2017, right? And that time this case was the latest judgment regarding right to vote, right? So there is one another reason that UPSC considered it as right to vote is constitutional right. Clear? Now, the most recent judgment regarding right to vote is, this is very important, Anup Barnwal versus Union of India 2023, right? And again, in this case, majority opinion, of Supreme Court, right? Supreme Court judges upheld that what? Right to vote is statutory right. right to vote is a statutory right. Clear? So if question comes in prelims 2026 that right to vote is, and four options are given: statutory right, fundamental right, constitutional right, natural right, human right, whatever, right, go for statutory right. Why statutory right? As per Anu Banwal versus Union of India 2023, Supreme Court with majority opinion, right, upheld that right to vote in India is statutory right. So it is crystal clear that right to vote in India currently is statutory right, though it has origin or links with constitutional provisions, but it has been clarified by the Supreme Court that it is statutory right. Clear? Now let's see right to votes in, right, current status. As I said that what is right to vote? Current status, you have to remember, statutory right. Right? Mark this. Right to vote in India, current status, right to vote. Why? We have seen the all the statutory provisions, constitutional provisions, but remember the Anu Barnwal case 2023. Right? Majority opinion of Supreme Court upheld it as statutory right. Clear? Now, right to vote in other countries, right? Other countries of world. So, for example, in European countries like Germany, France, right? It is considered as constitutional right. Yes, you have heard, right? I am writing in US, US, Germany, France, Canada, right? Right to vote is constitutional right. Clear? Now, another country like South Africa. So, in South Africa, right to vote is fundamental constitutional right. Fundamental constitutional right. Now, other countries like, for example, India, Australia, UK, it is currently statutory right. So here I am again writing India, UK, Australia. It is statutory right. Clear? So we have seen the constitutional provisions, statutory provisions in India, as well as we have compared other provisions, means other constitutions, right? So US, Germany, France, Canada, it is constitutional right. South Africa, fundamental constitutional right. India, UK, Australia, it is statutory right. Clear? And if question comes, as I said earlier, if question comes, you have to tick the statutory right. Means right to vote in India is currently statutory right. Current judgment means latest judgment, Anu Barnwal case versus Union of India 2023. So in this video lecture, we have discussed very key aspect, that is right to vote, and high possibility that question may be asked in prelims 2026. Thank you for watching.